Came back here, the real address is, yeah, but the address I gave out is here. I don't know why I took it off their website. Oh, did you really? Maybe it's an old number versus a new number thing, but the actual court is just down here about maybe half a mile or a mile. You'll see the town hall on the right, which would be that house, which is not the Tyrone court.
So Jeremy, while we're here waiting for a few minutes, you want to just explain a little bit of what's happened, why the judge moved you to...
We don't know. The short answer is we have no idea. We got a notice of a change of venue. It would make sense that the venue was changed because we had asked for relief from the order of protection which the judge in Cayuta placed upon me to keep me away from Barry Moon, the manager at the energy facility, who I don't know and would know if I ran into him. But we were never told the reason for this tonight. So we have no idea actually what this proceeding is. Somebody doesn't really think it's important for the defendant or his lawyer to know what's going on, and we don't.
And you said this judge appears to have a conflict of interest?
Well, yes. First of all, in addition to being the judge in Tyrone, he is also the emergency manager for Schuyler County. As such, he has to work hand in glove with Energy on formulating emergency plans should anything go wrong. So he's basically in touch with them, and he has already publicly stated that he doesn't see a need for any real special planning for an emergency up there. He doesn't think it's a big deal, apparently. Well, I'm supposed to now go, and I have been transferred without explanation for an appearance before a judge who's already taken a stance on the crucial issue. I'm here saying that we want to bring in expert witnesses for a justification defense, that it's so dangerous, I'm justified in committing civil disobedience, and the case, without explanation, has been transferred to a judge who's already basically said it's no big deal. Thank you very much. It's good to see you, Paula. You tell me what
I'm
you
sort
want.
of worn out.
I'm going to learn it all. I'll be ready to go.
There were two motions today, right?
Well, there's several motions. The first one was to have Judge Kennedy recuse himself because we believed that he had something to do with the investigation of the safety of the energy plant. He said in court that he reviewed his previous statements and recalls that he never really made any investigation. He was just saying that the county had sufficient protocols in place to take care of the issue. The judge denied that motion. He will not recuse himself, so he will try the case. We also filed a motion to vacate the temporary order of protection, which the judge denied because he believes that the order of protection law enables town judges to preclude people's liberty without any evidence. And I think it was a wrong decision, but he's the judge. We can file that, we can appeal that if we need to. The other motion was to allow expert testimony at trial on the issue of the imminence of the danger to the public, and the judge flatly denied that, saying that we don't have a right to even bring in experts to testify, which I think is an appealable issue. And then I think there was also a motion to allow experts to testify by electronic means, and he denied that. And that I expected, because there really isn't a procedure in town courts for doing that. We filed a motion for some discovery on the temporary order of protection. The judge denied that, but that really wasn't that critical of an issue. And then the judge scheduled a trial date of January 13th, 2014.
On one hand, we're saying that no one is contesting your right to have a plea of necessity, but on the other hand, we're saying you can't have any tools in which
That's right.
to do that, and we're going to make that determination ahead of any hearing.
Before even hearing evidence of the imminent danger. And that's where I think the judge made his mistake. I briefed that with a pretrial brief that the judge has. I know he's read it because he referred to it, but I guess he just doesn't accept the fact that experts are necessary. And judges do have the authority to preclude experts if they believe it's irrelevant. And the fact that he denied the use of experts makes me think he thinks the issue of imminence is not relevant, and that's where we're going to have a problem.
Which
on
gets
appeal.
back to the whole question of does he have a conflict of interest?
No, what I understood him to say about that was that there were already protocols in place in the county, so there wasn't any need for further safety issues because there's already something in place. And whether he was involved in the previous establishment of the safety protocols, I don't know. But to recuse a judge who just denies that there's any conflict or problem, it's a hard thing to do. And all the end result is that they just appoint another judge. So it really doesn't accomplish anything for my client.
Right. So what happened here tonight, Jeremy?
We didn't get anything we wanted. One issue is one judgment is in abeyance while the judge wants to consult with others about what he should rule. Actually, though, there's just one thing I want to say, which is that life is kind of complicated, and so things can go against you, but there's still a part of it that goes in your favor, and vice versa, which is kind of the yang and the yin of things. And even though all the rulings went against us pretty much, there's one thing that came out of this that I feel good about. This judge, even though he will not allow us to bring in experts on a justification defense, unlike Judge Berry in my first case, does seem to be willing to let me speak on my own behalf to that issue. Now, this judge, who also refused to recuse himself, which I think he should have, in my opinion, is the emergency manager for Schuyler County, and therefore works closely with Energy and looks at these things. He said today, well, I'm not recusing myself because my prior statement that didn't require any special plan was because there's a state protocol, not because I was taking sides. Okay, I'm not arguing that point. At the end of the day, if I get a chance to testify, I will be testifying to the dangers of this facility in front of the Schuyler County Emergency Manager, who is exactly the person who I want to hear it, even though he shouldn't be presiding, in my opinion. Nonetheless, the silver lining on this is that we get to address these concerns to the very Schuyler County official who most should hear them. And so that actually is a good result. Now, maybe we could put a sign or two like on the chain or something like that. Yeah, something like that. All right, well, here's the last piece of that, which is as part of our necessity defense, we subpoenaed documents, including the sonar readings on the caverns where the geologist reversed himself and said, oh, I've looked at this new evidence and they're paying me and it's okay, we can store gas here. Well, we subpoenaed all those documents. So if we were, which I don't necessarily expect, but if we were to get the brass ring on this merry-go-round and get everything we wanted and the appeals court allowed our justification defense, then we might be able to get those subpoenaed documents, and then it might be game over. I believe if anybody saw those documents, there's a good chance they would not be able to open this facility, and that's why they're keeping it secret. I don't know that for a fact. Yeah. But that was the prize, that the fact that we needed to try to get that was what made me have to appeal. I'm the only one in the legal position to pursue this because I'm the only one with a case that's open right now.